Edward White was born on November 3, 1845 in Louisiana. He was educated at Mount St. Mary's College in Emmitsburg, Maryland, and at a Jesuit college in New Orleans, even at a Georgetown College, now University in Washington, D.C. In 1861, he left school and enlisted into the Confederate Army. He was captured in 1863 by Union troops and remained in captivity until the end of the war. Upon his release in 1865, White read law and attended the University of Louisiana. He was admitted to the bar in 1866 and established a law practice in New Orleans. White entered politics as a Democrat in 1874 as Louisiana's senator. He served in the state Senate from 1874 to 1879 and on the Louisiana Supreme Court from 1879 to 1880. When the court was reorganized, he resumed his law practice. White was loyal to President Grover Cleveland, who appointed him to the U.S. Supreme Court. White was appointed Chief Justice in 1910, largely because of the ambition of President William Howard Taft, who hoped that by appointing a man of 65, he could succeed him. White was the first Associate Justice to be appointed Chief Justice. White did not lead the court into bold new areas of thought like everyone said. He instead followed the rule of reason. He sided with the Supreme Court majorly in the 1896 decision, which upheld the laws of segregation in the United States. Edward White once quoted, "The principle that there is a presumption of innocence in favor of the accused is the undoubted law, axiomatic and elementary, and its enforcement lies at the foundation of the administration of our criminal law." White served on the court for a total of 26 years, 10 of them as chief. He died on May 19, 1921, at the age of 75.
Kilo versus City of New London. The city of New London sits at the junction of the Thames River and the Long Island Sound in the southeast Connecticut. In decades, it suffered a shattered economy and a high unemployment rate. These conditions prompted state and local officials to target New London for economic revitalization. So they used its eminent domain authority to seize private property to sell to private developers. The city said developing the land would create the jobs and increase the tax revenues. Petitioners Suzette Kilo and other property owners argued the city violated the Fifth Amendment's taking clause, which is, no person shall be deprived of life, liberty, and property without due process of law, nor shall private property be taken for public use, without just compensation. Specifically, the property owners argued taking private property to sell to private developers was not public use. So petitioners took appeals to the Supreme Court of Connecticut. That court held over dissent that all of the city's proposed takings were valid, and such economic development qualified as a valid public use under both the federal and the state constitutions. Although we agree that the plan was intended to serve a valid public use, we have found all the takings unconstitutional because the city have failed to adduce clear and convincing evidence that the economic benefits of the plan would in fact come to pass. We granted certiorari to determine whether a city decision to take property for the purpose of economic development satisfies the public use requirement of the Fifth Amendment. When the Supreme Court unexpectedly agreed to take the case, much new national media attention was focused on the New London condemnation. Finally, the Supreme Court upheld the takings in a 5-4 ruling. Stephens G. and other 4 justices delivered the opinion of the court. In an opinion written by Justice Stephens, the court ruled that the New London project was constitutionally permissible and brushed aside property owners' arguments that economic development does not qualify as a public use in eminent domain cases. Clearly, there is no basis for exempting economic development from our traditionally broad understanding of public purpose, Stephens wrote. As with other exercises in urban planning and development, the city is trying to coordinate with a variety of commercial, residential, and recreational land uses, with the hope that they will form a whole greater than the sum of its parts, Stephen wrote, because that plan unquestionably serves a public purpose. The takings challenged here satisfy the Fifth Amendment. Justice O'Connor and other 3 justices filed a dissenting opinion. They said the Fifth Amendment to the Constitution, made applicable to the states by the 14th Amendment, provides that private property shall not be taken for public use without just compensation. When interpreting the Constitution, we begin with the unremarkable presumption that every word in the document has independent meaning. that no word was unnecessarily used or needlessly added. In keeping with that presumption, we have read the Fifth Amendment's language to impose two distinct conditions on the exercise of eminent domain. The taking must be for public use, and just compensation must be paid to the owner. These two limitations serve to protect the security of the property, which Alexander Hamilton described to the Philadelphia Convention as one of the great objects of government. Together, they ensure stable property ownership by providing safeguards against excessive, unpredictable, or unfair use of the government's eminent domain power, particularly against those owners who, for whatever reasons, may be unable to protect themselves in the political process against the majority's will. Historically speaking, there is one broadest definition for public use, which is the public benefit or advantage. Under this conception, neither title to the property after condemnation nor access to the property by the general public is necessary. Instead, property can be taken for any objective that the legislature rationally determines to be a sufficient public justification. This seems to be the definition of the public use clause adopted by the Supreme Court in the Kelo case. By the end of 2007, 42 states has passed some type of eminent domain reform to reform state laws and curb the abuse of eminent domain for private gain.
In the case of Snyder versus Phelps, Albert Snyder sued Fred W. Phelps Sr. The case took place in 2010 when the family of deceased Marine Lance Corporal Matthew Snyder filed a lawsuit against members of the Westboro Baptist Church and its founder. The family accused the church and its founder of defamation, invasion of privacy, and the intentional infliction of emotional distress for displaying signs that said, "Thank God for dead soldiers," at Snyder's funeral at Garrison Forest Veterans Cemetery in Maryland. District Judge Richard Bennett awarded the family $5 million in damages. But the U.S. Court of Appeals for the Fourth Circuit held that the judgment violated the First Amendment's protection on religious expression. The church believed that its members' speech is protected. The case went to the Supreme Court because the church members believed that their First Amendment right was violated with the decision. The Supreme Court affirmed the lower court's decision with an 8-1 vote, in the opinion of Chief Justice John G. Roberts, Jr. The court held that the First Amendment shields those who stage a protest at the funeral of a military service member from liability. Justice Samuel Alito filed a lone dissent, in which he argued, "Our profound national commitment to free and open debate is not a license for the vicious verbal assault that occurred in this case."